person. She doesn't have it. Okay. Christie, please. If you want to come up to that table there, please. Is this Mr. Clark there?
No, sir.
Okay, thank you.
I have no idea where he's at.
Okay. Whoever's connecting on Melanie Houston's iPhone, if you can unmute, please. All right. For the record, whoever that is not connecting. Judgment force forms.
Oh, I do over in the office. I could grab them. Yeah.
Okay. All right. We'll go on the record. Yeah, this is the matter of Clark versus Clark. This is case number 2314292. We have Miss Clark present here in the courtroom. This was set for a hearing at 1:45. It's now 1:50. Mr. Clark has not appeared either here in person or in the courtroom. And this is set for a request to enter a judgment of divorce. And Ms. Clark, is that how you wanted to proceed today?
Yes, sir. And I want my name changed back to my maiden name.
Okay. Let's take a look here. For the record, excuse me, it does look like Mr. Clark is the one that filed for divorce in this case. Busted by default. Set this for a hearing. Do you have any idea why he's not here? Have you had any contact with him at all?
I mean, not since, because we were supposed to be in here the 5th of December.
Mhm.
That didn't happen. And I didn't know if he was gonna show or not. He said Merry Christmas and Happy New Year to me. That's about it.
Okay. All right.
I don't know why
Are
there
there
would need to
any
be a hearing though.
Are there any issues regarding the division of any assets or debts
No, sir.
in marriage? Okay.
His or his, and we've been separated for 15 years, so.
Okay. All right. Then I'm going to ask you to raise your right hand. I need to swear you in. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Ms. Clark, have you been a resident of Kalkaska County for at least 10 days?
I live in Interlochen.
Okay. Do you know if Mr. Clark has been a resident of Kalkaska County for at least 10 days?
Yes.
Yes. Okay.
Sorry, she's my friend. She's helped me remember stuff.
Okay. Have you been a resident of the state of Michigan for at least 180 days?
Oh, yes.
Okay.
I've been here a year.
All right. In the complaint for divorce, there's a statement that says that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remain no reasonable likelihood that the marriage can be preserved. Is that true from your standpoint?
Yes, sir.
If the court were to not grant you a divorce, do you think there's any way that the marriage could be reconciled?
No.
Are there any children that were born of this marriage?
Yes, but he's 21.
Okay, so no children under the age of 18?
Right.
Okay. Are there any children that were adopted during marriage?
No, sir.
Are you currently pregnant?
No, sir.
You understand that as part of this divorce, you would not receive any alimony or spousal support?
Yes, sir. I haven't had it for a while.
So, and you also understand then that you would be waiving that forever and that you would not be able to come back later, ask the court for that.
Yes, sir.
Okay. And you indicated that any personal property has already been divided up between the two of you,
Yes, sir.
and whatever debts there are, each of you will be responsible for whatever debts that are in your own names.
Yes, sir.
You own any real estate or real property together?
No, sir.
Okay. And you're asking to have your last name changed to Thomas?
Yes, sir.
That's the THOMS.
Yes, sir.
Here. Do you own any, did I already ask if you own any real estate or real
Yes,
property?
sir.
Okay.
We don't have any.
Okay, the court finds that the statutory grounds for divorce have been met by the testimony of Ms. Clark. Court's reviewed the judgment. I filled that out. And according to the terms that Ms. Clark's indicated here on the record today, I've signed that judgment. So I'm gonna hand this back to you, Ms. Clark. You're gonna want to take this next door to the clerk's office to get this filed. You can get a copy of this for your record if you'd like to keep that. Because you're asking to have your last name changed, from today forward, your last name will be changed. So you probably do want to get a copy of that before you leave, because if you change your name or other documents, they're going to want to see a copy of that.
Right. Yeah, I figured I had to get 5 or so copies for banks and stuff.
Right. Do you have any questions at all?
No.
Okay, thank you. That's all. For today.
Thank you.
Gentleman is on Zoom. He called, he is here for France.
Okay, the one that I'm-
Mhm.
Okay.
I believe it was that same gentleman,
Thank you.
Leonard said. I told him to call me.
For me.
Oh, absolutely no problem.
All right, Mr. Leonardson, are you able to hear me okay?
No, I guess it's.
Yes, I can.
Okay, and let's see. Ms. France, if you can hear me, I need you to unmute yourself, please. All right, while we're waiting for that, Mr. France, if you can unmute yourself, please. Mr. France, are you able to hear me okay? Mr. France, can you say something so I can tell if your audio is coming through? Mr. France, are you able to hear me? All right, Mr. Leonardson, I'm not sure what we should do here because your client's connected, but apparently he can't hear me. Ms. France is connected, but she's not turning on her camera or her microphone. So I'm not sure how you want to proceed. I know it looks like just from the file, it looks like the case is settled.
I believe it's settled, Your Honor. I'm willing to take proofs. Miss France was one that filed. I represent Mr. France, the defendant, but I have prepared a proposed judgment and would like to enter proofs and certain sections of the proposed judgment and subject this to signing of the judgment, if possible.
All right, and I'm totally good with that. I think our bigger problem right now is I don't think I can communicate with either party in order to do that. Well, it looks like Ms. France is connecting here now. Ms. France, are you able to hear me?
Yes, Your Honor.
Okay.
She's the one that I would be putting on the stand, Your Honor.
Okay. All right, Ms. France, we're on the record in your case right now. And Mr. Leonardson, who's the attorney for Mr. France, has indicated that you have reached an agreement and that we're ready to finalize the divorce today. Is that correct from your standpoint?
Correct. Yes, correct, Your Honor.
Okay, so what I need to do is place you under oath, and then Mr. Leonardson is going to ask you some questions. And these are the questions that he's required to ask to establish the grounds for divorce under Michigan law, okay?
Okay, thank you.
So can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, Your Honor.
Okay, thank you. You can lower your hand. Mr. Leonardson, whenever you're ready, go right ahead.
Thank you. Miss France, there's a series of questions I'm going to ask you as it relates to a prepared proposed judgment. You have not received the judgment yet, but you're just going over the terms. My intent is for you and your husband to meet with me for signatures within the next 7 to 10 days. Do you understand that?
Can you repeat it, please?
Yes. As Mr. France's attorney, I have prepared a proposed judgment to enter for the court. I wish to enter proofs to get you divorced subject to the filing of that judgment. And I wish to go over certain terms within the judgment to verify that you have agreed to it.
Yes.
Okay. The spelling of your first name is Lilibent. Is that correct?
No. Lilibet, as in Terry, H as in Henry.
Okay. Thank you very much.
Thank you.
Did you reside in the state of Michigan for at least 180 days prior to the filing of your complaint for divorce?
Yes, sir.
And did you live in the county of Kalkaska for at least 10 days immediately preceding the filing of your complaint?
Yes.
Were you legally married in Luther, Michigan, which is Lake County, on November 7th, 1990, by a person authorized to perform marriages?
Yes, correct.
You have one child born of this marriage, Keen Lay France, who is an adult of 23 years of age. Is that correct?
Yes, he's 24 now.
94. Are you pregnant at this time?
No.
Your complete name before the marriage was Lilibeth Fortuna Teckling, spelled
Yes.
Tecling. Is that correct?
Yes, correct.
Has there been a breakdown in the marriage relationship to the extent the habits of matrimony have been destroyed?
What is that? Pardon me? Oh, could you repeat, please?
Yes. Has there been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed?
What's that?
Yeah, they're getting old.
You're, yeah, we're not, we're not get alone anymore.
Okay, and okay, then there isn't remained any likelihood that the marriage can be preserved?
No,
Okay. Do you wish to restore your maiden name or not?
if he don't mind, I can still keep his last name unless I'm gonna remarried.
Right,
Because we have a daughter, I want keep,
okay,
France.
I'll enter it as France, but you have the opportunity at any time to change back to your maiden name if you desire.
Yes,
You have participated in a mediation in November of this year, is that correct?
correct.
As far as personal property and household goods, you and Mr. France have come to an agreement as to what property is yours and what property is his, is that correct?
Yes,
As to real property, you don't share any real property, but he owns property. And you have agreed to mediation to not lay any claim to the property and sign a quitclaim deed releasing any potential interests. Is that correct?
yes.
Each of you have an automobile. You have an automobile.
Both it's my name. The old one is my name because he cannot drive.
Okay. As far as any pensions, you own a 401k, that's correct.
Yes, correct.
And he has a small claim in separate property. And each of you are relinquishing any claim to the other parties' retirement funds, correct?
I agree. We have agreement. It's my 401k. It's mine, and I don't wanna share to him. It's mine, and if he have a money or whatever he got his own. So
Okay, thank you very much. As far as any debts or liabilities, you have no assumed debt in your marriage, is that correct?
no,
You have
no,
debt,
no
debt,
debt.
both
No.
your names.
no.
Any debt that you would have would be in your name and you'd be responsible for, such as credit cards, correct?
Yeah, I have a car loan, so it's my responsibilities.
Okay. In mediation, you had agreed to relinquish any potential claim for spousal support. In exchange for that, you've asked to remain in the residence for a period of time. And it was agreed in mediation that you were allowed to remain in the property at no cost to you until December 1st of 2025. Is that correct?
That's correct. But I have a question.
Yes?
If he gonna kick me out of his property before November 2025, what I can do?
If he gives it up, well, he would have to negotiate because he has agreement with you to remain in the property to that time. So if he would give it up, it would be subject to you having possession of the property until at least till December 1st of 2025. but you must be out of the property by then.
Yeah, ask again.
Yes, but for example, if he's gonna kick me out before that, what I can do?
Are you home?
Well, I'm not your legal counsel. I'm not able to
Okay.
give you that information.
Just text her on there. Just text her on there.
Is there anything else that you have a question on as it relates to property or the settlement of this divorce?
No. I was gonna ask the Judge Merck later once we're done.
Okay. Now I have prepared a quitclaim deed for you to sign. The property is not in your name, but you are willing to sign that with to complete this divorce. Is that correct?
Yes.
She's on her way to my home, to your house.
I have no further questions of this witness, Your Honor.
Thank you. Ms. France, this is Judge Mertz. What was your question?
Hi. We have agreement. I can stay in the house until November 2025. How about if the dependent he gonna kick me out in his property before the November
So-
2025?
So you'll have a judgment, which is a legal document that does not allow him to do that. So if he tries to make you leave against your will before that date, then he'll be in violation of the judgment of divorce. So he
Okay.
can't legally.
Okay. Thank you, Your Honor. And
I have one additional question. Is there any
Sure.
reason why you would not sign a judgment of divorce within the next 7 to 10 days if we can meet?
no.
Okay. Thank you.
Okay, the court finds that the statutory grounds for divorce have been met by the testimony of Ms. France. The court will grant the divorce. Mr. Leonardson, as long as you can submit that to the court for signing, the court will sign that once it's presented.
Thank you, Your Honor. I will attempt to do this before the end of next week.
Okay, thank you. Mr. Leonardson, anything further from your side today?
I don't believe so.
Ms. France, do you have any questions at all?
Yes. How long or when is gonna final judgment the divorce? Because this coming May first week until June 20th, I'm out of state, so I just make sure I don't miss if it's still got another hearing or appearance.
No more court appearances. Mr. Leonardson will be in touch with you to have you sign that judgment and other documents, and then he'll get that filed, and then it'll be final. So that should all happen within the next couple of weeks.
Okay, that's all. Thank you, Judge. Oh, Your Honor.
All right, thank you. That's all for this hearing today. All parties on this case are free to disconnect at this time.
Okay, thank you. Have a good day.
Thank you.
Who's these other people?
Are you still on? Yeah, go on.
Okay, we have, I'm not sure how to pronounce this name, Tig Rose? What's that?
Tig.
Rose?
Yes,
Okay, you'll come forward, sir. Mr. Ziegler?
could I approach briefly, Your Honor, on another matter?
Yeah.
Your Honor, on the Dale Fields matter from this morning, it's come to my attention that he's actually physically in our custody in the jail. The writ was for an in-person hearing and they really got it.
Okay.
So I want to make you aware of that. And if we have time this afternoon to see him, I think Mr. Holman said he could make himself available.
Okay.
So I just wanted to make sure you were aware.
Okay, thank you.
Give my office a call if we can see him today, or if not, then I guess we'll sort it out.
Okay, sounds good. Thanks for the information. Appreciate that. Okay, Mr. Rose, if you want to come forward, and then do we have Sarah Rose here as well? Mr. Rose, you can go over to that table there. So the record should reflect both parties are present here in the courtroom today. And Mr. Rose, did you want to go forward with finalizing the divorce today?
Yes, Your Honor.
Ms. Rose, is that how you want to proceed?
Absolutely.
Okay. All right, so I'm going to place you both under oath. I've got some questions that I need to ask each of you. The questions I'm going to be asking are those that I'm required to ask to establish the grounds for divorce under Michigan law. And so if you both would raise your right hands, please. Do you both solemnly swear or affirm the testimony you're about to get will be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Thank you. Mr. Rose, you filed a complaint for divorce in this case, is that correct?
Yes, Your Honor.
At the time you filed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Kalkaska County for at least 10 days?
Yes.
In that complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that your marriage could be preserved. Was that true at the time you filed that complaint?
Yes.
Does that remain true today?
Yes, Your Honor.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, Your Honor.
And as part of this divorce, you would not be receiving any alimony or spousal support, is that correct?
That's correct.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes, Your Honor.
Have you already divided up whatever personal property the two of you had?
Yes.
And do you own any real estate or real property together?
No, sir.
And as part of the judgment, you would each be responsible for whatever debts are in your own name, is that correct?
Correct.
Right. Thank you. Ms. Rose, have you heard all the questions that I asked Mr. Rose?
Yes, Your Honor.
Have you heard all of his answers?
Yes, Your Honor.
Do you have any reason to believe that any of the answers he gave were not true?
Yeah.
Are you currently pregnant?
No.
You understand that you would also not be receiving any alimony or spousal support?
That's just fine.
And you understand that you would also be waiving that forever and would not be able to come back later and ask the court for
Yes,
that?
Your Honor. That's fine.
And do you agree that you don't own any real estate and that there aren't any
No,
items of
no.
property to be divided or?
No.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of both parties. The court will sign this judgment. And grant the divorce. Ms. Rose, did you wish to have your last name changed?
I prefer that right now, but I have so much stuff in my name, my bank account, my work pay card, everything. So right now, I kind of like to keep that so I can kind of get that situated where I gotta do. Then I'm more likely if I would change it back. Right now, it's inconvenient right now, type of what I gotta do.
You can change it at any time if you would like to, but the court will not order that it be changed as part of the judgment
Thank
today.
Thank you.
Okay, so the divorce is final. This will be filed today. If either of you need copies of this for your records, you can get that from the clerk's office right across the way. Mr. Rose, did you have any questions?
No, sir.
Ms. Rose, did you?
Sure, yeah.
Thank you. That's all for today. The documents. From corner of the desk. For the next case, yeah, it's the analysis versus the case.
I don't have that.
That's okay.
Oh,
I don't-
okay. You know it by heart.
I might have it too, by the way. All right, looks like we've got everybody connected. If I can have all council unmute and we'll go on the record in Nellis versus
Kalkaska and Munson Healthcare. This is file number 21-13787. If I could have counsel put your appearances on, starting with plaintiff, please.
Good afternoon, Your Honor. James Elliott on behalf of the plaintiff, Ed Nellis.
And Your Honor, John Elliott also on behalf of Mr. Nellis.
Good afternoon, Your Honor. Nick Artev on behalf of the Kalkaska defendants, as well as defendants Miller, Bryan, and Aylesworth.
Good afternoon, Your Honor. Charles Fisher on behalf of defendant Munson.
All right, thank you. We're on the record today for a motion to compel by the plaintiffs. As pointed out in the briefs, the court, there still is pending a ruling on a previous motion from back in November, which that should be released to the parties any day now. But this involves, at least ostensibly, different requests or requests that were made subsequent to that hearing. I've had a chance to review the plaintiff's brief and the documents in support of that. I've also received response from the relevant defendants to this motion. I don't think Munson's really necessarily involved directly in this. So I've had a chance to review all that. Mr. Elliott, anything that you wanted to state for the record in support of your motion today?
Yes, Your Honor. There's only 3 interrogatories and 7 requests for production of documents we're referencing throughout this motion. I need to point out 2 things before I commence. One, the court rule MCR 2.309 B13, which I cited, which requires the parties and or an agent on their behalf to sign each and every responsive interrogatory under oath. And secondly, in order that you entered, it's attached to our motion as Exhibit F. 1 year ago, exactly tomorrow, January 4th, 2023, we appeared before Your Honor on a very similar motion, a motion to compel by the plaintiffs against all defendants. At that time, you took arguments and you entered an order, which again is attached as Exhibit F to our brief. Within that, you indicated that you found their responses, the defendants' responses, were minimally responsive, overly broad, and in general, they were inadequate. You then went on and you gave them very strong, what I believe is a very strong directive. You told them, you gave them 3 choices. 1, produce the document. 2, if you don't produce the document, defendant, you must state whether or not it exists. And 3, if you're not going to produce it after you state whether or not it exists, then you must give an argument and authority as to why you should not present it. 1 year ago, to this date, we have not received 1 document in response to what was requested, or what's being requested today. That's why I'm referencing this order. And 2, we have not been told by any defendant whether or not any of the documents exist. Not 1. I challenge any of the defendants to show us where they say it's existed. They just say things are non-responsive, but they don't indicate whether or not they exist. You go on to state that, again, if they have a real objection, and that's your terminology, they need to provide the specific authority. I would ask that the court, number 1, order that all past and present and future interrogatories be signed. This keeps getting away from us. I keep asking it at every motion. They continue to file their responses without having them signed by a party or an agent and without having them sworn to. This time, we finally received 1 response that was signed by Mr. I think it was Miller. None of them have been sworn to. So effectively, we have no answers we can rely on. I would really like to get this case moving and off dead center. We need documents, Your Honor, before we can start deposing these people. And everything they've done thus far has been completely evasive, game playing, in my opinion, and sometimes untruthful. That's a rare statement that I make, but that's going to be pointed out in what I'm going to address the court now. I'd like to group these requests together because they're related. If you take I'm going to address Mr. Ellsworth. Mr. Ellsworth was the coordinator of the rehab facility where Mr. Nellis was being taken.
Mr. Elliott, and I don't want to short circuit you here, and I want you to give you as much opportunity as you want to argue. But what would be helpful? Did you get the defendant's responses to your motion?
I did, and that's what I'm addressing right now.
Okay, great, because that's really what I'd like to know is what.
That's it. I'm just telling you who these people are so you have an understanding, Your Honor. Mr. Ellsworth is a defendant. His request to produce number 2. He was asked whether or not, or asked to produce telephone records of a telephone call that he swore to in an affidavit that was presented to Your Honor in a motion to summary disposition, that he called Mrs. Nellis and told her what transpired and that he was getting her husband immediate treatment. This is contrary in defense of what was alleged in the verified complaint. It was verified in the complaint that they have attempted to cover this up, that they have never told her what transpired. In fact, she didn't know what transpired until a year and a half afterwards when we got a copy of the video. So in response to that, the defendants produced this affidavit thinking it was relevant. In the paragraphs, I think 10 through 14, the defendant said he made a telephone call to Mrs. Nellis telling her what transpired. She came in and he discussed it with her and was going to get her husband treatment immediately. It's been stated in the complaint that that's untrue. Mr. Ellsworth denied it and went as far as swearing to an affidavit. We requested a copy of his records because it never happened. He never had Mrs. Nellis's number. So what he did, he actually perjured himself when he signed this affidavit with the court. That's a very strong, serious statement I'm making. And then 3 days before I received his answers, where he said he did not have the records, that his employer, Kalkaska Hospital, has the records, I got a call and 2 emails, and they're attached as Exhibit, I believe, 8 from the defense attorney that's appearing before Your Honor now. And he told me in the emails that they do have the records, the telephone records. They're reviewing the telephone records, and they're trying to figure out which number was Mrs. Nellis's. We don't need to tell her we don't need to tell him what number Mrs. Nellis's was because he never called her. If he had her number in the records, and it's against the law to destroy medical records, then he would know what number he called. So even though the attorney told me in 2 emails and during a telephone conversation 3 days before the attorney sent the answers on his client's behalf, he said, we have the records, we just don't know which number is hers. Mr. Ellsworth says he doesn't have the records. Your Honor, this is probably the most flagrant, untruthful statement that I've seen in this case up to this point. We have the attorney saying his client, and he names them. He names Mr. Ellsworth and Kalkaska. He said they both have the records. Mr. Ellsworth said in his response, I don't have the records. Kalkaska has them. Kalkaska says, we don't have the records. I want the records, whatever records he was referring to, or I'd like him to state to the court, as an officer of the court as I am, that he misled me in these emails saying that they had the records. So that's the first response in reference to Ellsworth and Kalkaska. Ellsworth is Exhibit A, Kalkaska is Exhibit D. The request to produce was number 2 for Ellsworth, and the request to produce was number 1 for Kalkaska. You want me to move on to the next one, or?
Yes, thank you.
Your Honor, the next request is also to Mr. Ellsworth. Exhibit A, once again, his answers, his responses. He was requested to provide, in fact, once again, I'm going to refer to his affidavit, Exhibit G, paragraph 9. He stated that he directed a nurse to have a staff physician and a physician assistant to evaluate Mr. Nellis. All I asked for were the records showing where a staff physician and a physician assistant evaluated Mr. Nellis, because it's our belief that they allowed him to lay in this bed in a small room in a rehab facility attached to Kalkaska Hospital for 3.5 hours with 6 broken ribs, a punctured lung, life-altering injuries without getting any treatment. But Mr. Nell, and that's what we said in the complaint. But Mr. Ellsworth said, no, he got treatment. So I said, give me the records. They said, we gave you the records. I said, and I told the attorney when he called me, please give me the specific pages. And they refer me to 62 pages of medical records. I went through the records over and over. Nothing in there about an evaluation by a doctor and a physician assistant. I'm just asking for the records. They say they exist.
Can I ask you a question about that?
Yes.
If it's your, if you have documents that say that he ordered this evaluation or he submitted the affidavit and they're saying, here's our response, go to pages, whatever, and you go to those pages and you don't find that, isn't that there we are, right? You've got a response that says it's there, and then, if that
normally
clicks
yes,
or doesn't match up.
Except it's a
So
broad.
if that's what they're saying they have, do you want them to make up something and give it to you? If they don't have it, they don't have it, right?
And I would like them to say that, because these 62 pages, all of them are not authored. I don't see any doctors' names. I don't see any physicians' names on them. But if they later on at trial say, oh yeah, Elliot, here, this page here, 78, no names on it, but this was authored by a doctor. I just simply, there's only 62 pages. I don't see any doctors' names and physician assistants' names. I would just like them to give me the page, what I requested. It's a simple ask,
Okay, but
and then I can
if
put
that
the
isn't
rest in my
there,
mind.
if that information isn't there, what else do you want me to order them to do? Like I said, that can't make them.
They're saying it is there. So as an officer of the court, I'm believing them. So is it there without their name on it? Which one is it? I can't discern which one it is, Your Honor. They're saying it's there, must be there, but there's no names on it. Can they please give me the pages that show the evaluation? That's all I'm asking for. I can't discern it. They're giving me a whole stack of papers. It's in there someplace, Elliot. I reviewed it, Your Honor. I can't find it.
Then I guess, wouldn't your argument be there then that if we're at trial or an motion hearing or wherever this becomes the issue, isn't your argument then that whatever they say isn't credible because they're giving you, they're saying in one hand that they did this, and on the other hand, they can't produce any records that confirm it? Doesn't that help prove your case then?
100%, as long as I don't have a surprise where they pull out a page without a name on it and say, oh, here it is. This is it. Doctor didn't put his name on it, but this is it right here. I'm just trying to cross the T's and dot the I's.
And
they could have had it done by the time we filed this motion.
If that happens, then I suspect you would have an argument saying we request this specific document in discovery. They said they didn't have it, or they pointed to other documents, and so it shouldn't be admissible. That's how this works, right?
Unless you're the judge, and if you're saying if it's not signed, you're not going to admit it, I'm fine with that, Your Honor. But if they pull it out of the documents that they gave me and says, no, this is it. I didn't tell you there was a doctor's name on it, Elliot. I just said it's in these pages. I'm just trying to do my due diligence. I'm not trying to be excessive. I just want to see where they evaluated him.
I get it, but I just don't know what else. I can't, if they're, number one, first of all, I agree, you should have signed. If they're going to give responses, they need to be signed. And I am going to make that part of the order today, because I do think you need to be able to rely on whatever responses they give. But at some point, if the response is we've already given it to you or we don't have it, I understand that you may think that they do have it and they're just not turning it over. But at some point, you know, as at least as far as it goes with written discovery, I can't just say, well, I agree with plaintiffs. I think you have it. So, you know, find it and produce it. You know what I mean? Like, I mean, we've all got to go with what the sworn answers are. And if that's untruthful and it comes out later, then there's going to be penalties for them to pay for that in various ways that could be sanctioned. So, I mean, I agree that the discovery needs to be signed pursuant to the court rules, because I agree that you need to be able to rely on what they give you. But if they're saying they don't have it, or it's that document doesn't exist, or they're saying we've already given it to you, then I don't know what else I can do beyond that. You know, I get to the point where it's like, you saying you think they have this or they haven't produced it, and they're saying we've given them everything we have. I'm in a position where then whatever the signed responses are, what everybody's going with.
I just want to make sure that it's not a page hidden in there without the name on it of the physician or the physician assistant. That's all I'm trying to do. So there's no surprises at trial, just straightforward. That's it. That's all I'm requesting, Your Honor.
Okay.
If they got the page, they're all stamped. They're all have a date, a timestamp on it, a page number. They could say it's on page 76. They don't have to say it's on all the pages, because it's not.
Well, why wouldn't you be able to go through it? I mean, why do they have to point you to the exact page if they've given you all the documents? Why is it up to them to say, okay, it's on page 72?
Because I did go through it, and there's not a single signed page with a doctor or a physician assistant's name on it. Therefore, if it's one of these unsigned pages, I'd just like them to tell me so I can look at the results of the evaluation and see what time he was evaluated and how they evaluated him. But there's nothing in there. I've never seen a record like that. I don't think they have it.
All right. Okay. All right. I'm sorry. We kind of digressed there. Please proceed with the rest of your.
Okay. And then, Your Honor, I can group three additional requests together. Defendant Aylesworth, Exhibit A, request to produce document number 1. Michael Bryan, Exhibit C, request to produce document number 1. And Defendant Yale Miller, Exhibit B, request to produce document 2. I asked to see information from all three of them. I just basically asked a simple, provide me any date, any documents, statements, or reports that you yourself, no one else, that you yourself generated regarding the incident, anything. And their responses were identical. All three of them said, we have produced non-privileged documents. But they don't, one, they say they produced non-privileged documents, and 2, they say, I do not possess a copy of the responsive documents. They never say whether or not it exists. We still don't know, even though Your Honor ordered almost a year ago that they tell us these responses they have. I don't know whether or not they ever authored a document like that. They're saying there's non-responsive documents. Did they take that and put it in the non-responsive pile? What they're calling, peer review? I don't know. It's not up to them to call it peer review. Their second response is saying, we don't have a copy of the response. Well, does that mean they don't have a copy of the response because they gave it to their employer? MCR 2.309, again, requires that if they have access or can get it, and they're all using the same attorney and they're still employed by the same person, then they should get this. I just want to know, did they fill out a statement? So when I take their depositions, which I would like to do, if I can cross-examine them on that and see what they said then compared to what they say today or at the time of their deposition. In violation of your order, not one of them said whether or not it exists. And they didn't give any authority. Okay, Your Honor, it does exist. Ellsworth, Bryan, and Miller, let's say they all say they gave a written statement, which I assume someone did someplace. Then I can argue if they say it's peer review, then we can talk about that. But I don't even know if it exists. And again, that's in violation of your order, Exhibit F. So I'm asking that all three of them produce the document. They had the chance to say whether or not it exists. If it does exist, I think I should be entitled to it 3 years post-incident.
Okay, all right, thank you. Mr. Artea?
Your Honor, I have a couple more.
Sorry. Okay, go ahead. I'm sorry.
Yale Miller, Exhibit B, defendant. And he's one of the, Miller and Bryan were the two EMS individuals. Request one, I requested the EMS records that he said he prepared. He also filed an affidavit, Your Honor, with you in response to the, in support of the summary disposition motion. And he indicated that he relied upon the EMS records that he produced. I just wanted to see the EMS records that he said he produced because I can't find them. And his response was, see the records produced by Kalkaska. Kalkaska didn't produce any statements from him, any EMS records that he produced. I just want to get what he's saying exists in affidavit form. And they're not providing it. Again, violation of this court's exhibit, this court's order, Exhibit F, that you pronounced on February the 4th, I'm sorry, January 4th, 23, and entered, I think, on February the 1st, 23. So I go on to the next one?
Yes, please. Thank you.
And then Kalkaska's response, production of documents, Exhibit D. I asked them to produce records of the exam of the plaintiff performed, this is similar to the other one, by the physician and the physician's assistant, which reflected in Ellsworth Exhibit G, the affidavit presented to Your Honor. They said, please see the medical records. Again, I looked at the medical records, they're not in there. Can't they just, is it gamemanship? Can they say it doesn't exist or it's on page 57? They gave me the exact page numbers to look at. And it's not in there. So why, they gave me a group of 62 pages. Why can't they just say it's on page 62 or whatever page it's on? Your Honor, so lastly, I presented a proposed order, Exhibit J. It kind of goes through what I just requested. I also attached the proposed order from the November 6th hearing, but you said you're taking care of that and handling that. But I would like to get these responses so I can move on and start scheduling deposition. It's been a long case. It's like I said, 3 years now post-accident, and I know we had the holdup because of the pandemic and the SD motions and the governmental immunity. I would like to go back to one more thing. They keep saying in every response that we exceeded our number of interrogatories, and I gave the court a list, Exhibit E. We're not even close to the number of interrogatories. I don't know why they keep saying that, to Your Honor. As an officer of the court, they keep telling you we exceeded, we exceeded. The only one that exceeded was Kalkaska. We had 25 to them. And I guess I would like some clarity from the court. We were dealing with governmental immunity issues. Am I restricted to the 25 governmental immunity interrogatories, or can I exceed that now on these cases now that we're beyond that and into proving negligence?
Okay, thank you for raising that issue. I'd like to hear from opposing counsel when you're done with your argument, and then I'll address my ruling.
Thank you, Your Honor.
Thank you, Your Honor. First, I generally just like to point out, I think Your Honor understands the issue here in the sense that we've, essentially provided the information. We've indicated that in our responses, but for some reason, plaintiff's attorney thinks that there's additional documents that we need to produce or have that we haven't produced. And I agree, as Your Honor just pointed out, how can an order effectuate, for us to produce something that essentially doesn't exist anymore? But going back to the specifics of the arguments raised by plaintiff, I think the first thing, Your Honor, I would ask for a little bit of clarity on the interrogatory signatures, because we did provide signatures on these latest interrogatories from Mr. Aylesworth and Mr. Miller. Plaintiff's attorneys, claiming they're not filed under oath, but Your Honor, I mean, we've indicated they're being verified by these clients. I don't think I've ever had to produce, interrogatory responses where I'm not sure if plaintiff's attorney is, wanting us to get these notarized or something else, but I don't think I've ever had to produce interrogatory responses that were notarized by someone or signed under by other witnesses or something like that. But as to the number of interrogatories, it's an objection we're just going to we continue to make. We do it to preserve that argument. I think we believe that the interrogatories are excessive at this point. They're asking for a lot of the same things over and over again, just in different ways. And Your Honor, it's an objection we continue to make just because, based on our understanding of the court rules, that they've exceeded this at this point. But regardless, that issue is immaterial because we continue to respond to the best of our abilities. As to the writings, I think that the plaintiff alleges, Mr. Miller and Brian and Aylesworth all may have made regarding this case. I'd just like to clarify for the court, and perhaps this will provide plaintiff with some clarity as well. The only writings that were ever made by Mr. Miller and Mr. Brian specifically were entered into an electronic system that goes directly into Kalkaska's peer review system, and it's done specifically for that peer review system. I think my answers and our answers were essentially meant to communicate to plaintiff that they're not in possession of any sort of like personal diaries, records, notes that they made in conjunction with this. As to the fact that Kalkaska maintains these writings and reports, again, Your Honor, we've made these objections multiple times on nearly identical requests for discovery that plaintiffs have made. These are all just squarely under the peer review privilege. We haven't had one single argument, case, citation to a statute, anything from plaintiff that indicates that we're supposed to produce these writings and documents. And Your Honor, Michigan law is very broad and expansive and all-encompassing with these particular documents, so I don't think they're going to find any such authority. And I don't think the court will find it very convincing, even if there might be something out there. As to the phone records, Your Honor, the phone records, it's an interesting argument from plaintiff. I think he just indicated that he doesn't think they exist. Again, wants us to produce something he doesn't think exists, and then files a motion to compel when we don't produce something responsive. I think that kind of summarizes how he's been going about discovery in this case, and thinking that there's something out there. He knows that, he thinks there's something out there, but then when we don't produce that something, he claims that we're hiding it or we're not producing it. I indicated in my emails and my communication with plaintiff's counsel that we have a phone. We ran a search on Mr. Aylesworth's phone extension that we believe was associated with his phone extension on that date. And that record produced a number of different phone numbers. We can't just produce that phone log and that phone record containing all those phone numbers because we don't know what Mrs. Nell's number is. Essentially, we wanted confirmation from plaintiff's counsel of what her phone number was to understand whether we have any responsive documents that we're able to produce. But plaintiff's counsel refused to provide us with that number. We've made the request in our written discovery, so I anticipate we'll get that information. We can run another search and see if there are any responsive documents. To that effect, Your Honor, we can't produce the phone record as is simply because otherwise we'd be producing patient protected identifying information, be direct violation of HIPAA, of other privacy protection laws. We can't just produce a document with random phone numbers of patients and medical providers from Kalkaska. So that's the explanation for why I indicated that we did have a search run for that particular number, but we're unable to produce it. So plaintiff isn't wrong in the explanation. It just the explanation I think is more is I guess trying to make it seem like we're trying to again cover something up or protect something. And regardless, Your Honor, I think we made this point in our briefing. This phone record is irrelevant. Plaintiff's counsel himself just indicated the reason why he wants this phone record. He wants it to indicate that there was a cover-up conducted by Kalkaska Hospital and that Mrs. Nellis was unaware of this particular incident or what happened to her husband. But Your Honor, that claim was dismissed by this court in that summary disposition motion. All that's at issue in this case is the negligent handling of the gurney, allegedly negligent handling of the gurney. So he's claiming that, these are things that he's alleged in the complaint, but the complaint's changed since that point, Your Honor, since the granting of 9 out of the 10 counts of the summary disposition motion. But regardless, we've made an effort. We've tried to produce responsive materials. But at this point, we're unable to produce any responsive materials. So, Your Honor, with that, I'd be happy to answer any other questions. But again, as you've indicated, with the EMS records, with these subsequent, medical records, I'm also a little bit confused as to why plaintiff's counsel thinks that they're all unsigned. I'm looking at the medical records right now, and I see signatures from several doctors and nurses, and they're all electronically signed on that date. I'm not sure if plaintiff's counsel just isn't familiar with, maybe Kalkaska's version of medical records or how they're formatted or what's going on. But, I'm looking at the medical records right now. They're signed by numerous different doctors. We have, I believe we've submitted, witness lists in this case that indicate some people who might have information. Your Honor, I'm not sure what's going on with that particular argument, but again, we've produced the EMS documents. We've produced all the medical records that Kalkaska has in this case. And I'm not sure, there's anything else for us to produce at this point, so.
All right, thank you. Mr. Elliott, anything you wanted to say in response?
Briefly, Your Honor, reference to all the doctors he has signatures on. Tell me which doctor did the exam. I have records with signatures on it too, starting at 6:38 p.m. after he was transferred to the emergency room, after he laid in the hospital bed for 3.5 hours. I'm asking for the records showing that he was evaluated during that 3.5 hour period. If the attorney is telling you, Your Honor, that he has records with the doctor's name on it, have him shoot it over to me and then we're done. But I do have records. I do know how to review records. I've been doing this a couple of years, and I just don't see any during that time span when he was laying in the bed. So give me the doctor's name at least and the physician's assistant. In reference to the documents that he says they electronically filed into peer review, that's the first time I've heard of this. So it sounds as if they are saying that they have documents, that documents were produced. If those are the only documents that were produced, then can they tell me that instead of the attorney saying it? Can they put it in a written answer and sign it and date it? We've already addressed, I think this is the 5th attorney on the case on behalf of this defendant. We've addressed peer review. We briefed it extensively. In your honor, and this was our first motion to compel, I think your honor agreed on the record that peer review is not as wide, nearly as wide as a net as the defendants allege. So they're saying we're going to take every single document, we're going to dump it in the peer review basket, and no one can touch it. You made it clear that it wasn't as wide as they said, but we don't even know if they have the document other than this attorney now telling us for the first time that they put something in electronically. If they do have statements, I would ask that your honor be able to do an in-camera review of the statements, and we can rebrief it again, but we spent a lot of time on the brief. We'll do it again. And again, I think your honor will agree that these are not peer review documents that they have. In reference to the telephone records, he says you dismissed a count that would make these moot. I don't think so. The telephone records go to show two things: credibility and damages. Credibility on the part of the defendants. You know, if they're lying about one thing, what else are they lying about? But it clearly goes to the part of damages. Mrs. Nellis had the power of attorney to Ed Nellis on that day. They knew she had the power of attorney and that he was unable to speak. She didn't know that. She didn't know that he was laying back there because they never told her that he just got dumped on the pavement, had 6 broken ribs, and laid there in agony. She didn't know any of that. Had they told her that, yes, this happened, she would have insisted that he be placed in emergency immediately and get treatment. These phone records are relevant for numerous reasons, clearly damages, clearly credibility. When he was dumped on the pavement, your honor, it was your honor indicated you looked at the video before. It was right outside of the door into the rehab facility. A few feet to the left was the door going into the emergency room. Instead of the EMS knowing what they did to him, took him into the rehab, stuck him in a bed, and left instead of going a few feet to the left, same building, and getting him treatment, which they were supposed to do. He was critically injured. His family was called to the hospital at Munson when he was transferred there and said, he's going to die. Come and say your last. This isn't just a little tumble off into a snowbank like was described. It's a very serious injury. In reference to the attorney said, even though he knows that we are within the limit of interrogatories, he's going to continue to object. He's an officer of the court. I don't know. I've never heard someone say that, your honor, that he's going to continue to present frivolous objections. We either exceeded it or we did not. In reference to the answers being sworn, we have one answer being sworn by one person. The other one has a typewritten name on it. It's not a signature. And the funny thing is that the interrogatories I just got from this attorney demands that you must sign the answers under oath. This is a document that he sent my client through me saying that they have to be signed under oath. And he said he's never heard of that. That's my response, your honor. Thank you.
All right, okay.
Briefly, your honor, just to address this issue with the peer review documents. I don't know why plaintiff's counsel keeps ignoring the fact that we've supplemented our responses nearly a day after the court ordered us to essentially either explain why we can't produce these documents, and because the second request for production that the plaintiff's counsel sent are nearly identical to the things, or they are identical to the things he's requesting in this case, or in this present motion. And we made very detailed objections to those exact same requests for production. We've provided statutes, case laws, numerous citations. Each objection was, could qualify as essentially a brief in response to a motion to compel. But I don't know why he thinks that we've ignored the court's order in that regard, and why he thinks that we haven't told him that there are documents that were made, but they're protected by peer review. We've gone through this argument before. We were here in November talking about this exact same thing right now. So, your honor, I'm not sure what else can be ordered right now at this point, but we'll be happy to answer any other questions.
Can I just briefly respond, Your Honor?
Sure.
These are not the identical requests. So again, he made a misstatement to the court. I never requested the phone records, things such as that. I never requested the exact statements. I didn't even have the affidavits I'm referring to. Most of them are completely new requests. And lastly, in reference to the phone order, if they don't want to send me the records, we'll do a protective order. And then that takes care of any violation. But again, I just need the one number that he called, that they said they contacted Mrs. Nellis on. Simple as that.
Why won't he
All right.
give us the phone number then, so we can figure out if it's responsive?
I guess, Your Honor, my question to him then, in my response to the court, did they destroy the number? Where is the number that he called? These are medical records. They're mandated, as I don't want to keep repeating myself, so I won't, but they have to have the record. If he called her, they've got it.
I mean, do you guys, this is on YouTube, so maybe you guys can go back and watch this later, but to me, it's a little ridiculous with this phone thing. Like one side saying, well, we need the phone number to be able to figure out whether there's a record that complies with the request, and the other side saying, well, we're not going to give you the number because you should know what it is, because that's the call that he made, and that's the one that, I mean, it's ridiculous. And the amount of time that we've spent, I'm going to go back and just calculate the amount of minutes that we've spent on the record on discovery issues since this case started. I'm willing to bet that it's in the hours, because we got another at least 45 minutes today. And frankly, I don't know, this case stands out to me as one of those cases where I think both sides are being completely unrealistic in what's going on with written discovery here. And I think everybody needs to move on from these interrogatories and requests to produce, start doing some depositions, see what kind of answers you get in the depositions, and then follow it up with more written requests if you need that. But it seems to me like this is the goal here is to try this case in discovery. And the whole purpose of discovery is to get information that's going to help you to move on to the next phase. And I just see everybody stuck on requests to produce and interrogatories with the defendants providing the bare minimum that's arguably responsive, and then the plaintiff saying, well, we want more information, and we're not happy with those answers, and bringing it to court. Like, I am going to be able to figure that out for the two of you, for both sides, because I don't know what the defendants have, and plaintiffs aren't happy with the responses they're getting. So it puts the court in a position where we just go round and around and around, and nobody's getting any further. I do think, as I said at the beginning, that the plaintiffs are entitled to responses that comply with my previous order that Mr. Elliott referenced. They're entitled to responses that are properly signed and verified as required by the court rules. And so to the extent that, and I'm dealing solely with the discovery requests that are at issue in this motion, because I'm going to address some of what I view are probably overlapping issues in the written opinion on the previous motion. But solely with regard to the request here, the court's going to grant the plaintiff's motion to the extent that the defendants need to resubmit their answers with proper verification from the party that the discovery is directed at, in strict compliance with the court rules, and in that the answers are to comply with the court's prior order, as Mr. Elliott indicated, in terms of if you don't have it, then say you don't have it. If it's in the possession of another party, then say it's in the possession of another party. And that, again, that they be properly verified, and then the defendants are stuck with the answers that they gave. And if that's a problem for them later, then that's going to be a problem for them later. But I don't think there's really anything else that I can order at this point. So Mr. Elliott, if you'll prepare an order that reflects that ruling of the court today and submit that, and the court's going to require that those supplemental or additional responses pursuant to the court's order today be provided within the next 30 days.
And Your Honor, may I ask about the number of interrogatories going forward? Are we,
Right. Thank you. I appreciate you bringing that up. I meant to address that and I forgot. It's my view that that we had a limited period of discovery related to the immunity issue that I think is separate from ongoing general discovery. And so I don't view the plaintiffs as being over their limit in terms of what they've submitted for written discovery.
does it start fresh now, Your Honor, with number one, or how do we do that?
I really don't know the answer to that question. I don't think that's something that I need to rule on. I think counsel, you guys are gonna have to figure that out.
Okay.
All right. Thank you. That's all I have. All parties are free to disconnect at this time.
Thank you, Judge. Have a good
Thank
day.
you, Your Honor.
Thank you.